Tristram Hicks has had an extraordinary career in financial crime from a law enforcement perspective. As a detective inspector in London's Metropolitan Police Fraud Squad in September 1999, he's been a detective chief inspector, a detective superintendent, from where he moved on to Bramshill Police College as an international policing advisor, and then on to his own consultancy. He's been involved in long-term government-level financial crime projects in the Balkans, Jamaica, Kenya, Mongolia, Croatia, Serbia, Tajikistan, Turkey, and northern Cyprus. In short, pretty much anywhere others fear to tread. He recently published with Nicholas Gilmore, The War on Dirty Money. He'd be an ideal candidate for FinCrimeTV's Shoulders of Giants series, but today he's with us on Uncommon Sense as we discuss some current topics from a critical thinking perspective. Tristram, welcome.
It's a pleasure to be here, Nigel. Thank you very much for inviting me.
I've rattled through some of your experience on a very superficial level. Why don't you tell us a little bit about how all of that informs the views that you hold today?
Well, I had the privilege to be both in operational command of all the financial investigators for the Met Police, and at the same time on the National Committee, just after the Proceeds of Crime Act was passed in 2003. And I turned up at that meeting, and then unexpectedly I was still there 10 years later when that committee had implemented what was a spectacular change to the way we addressed criminality in London and indeed the whole country. The Proceeds of Crime Act really made a huge difference. And before that, basically, everyone who's convicted kept all the money that they're being convicted of. And sadly, that's still the case in 80% of the countries around the world now. So there's a lot to be done, but we have an example of success in the UK.
Yes, I think one of the things that was particularly fascinating, I mean, the Proceeds of Crime Act is one of the worst drafted pieces of legislation anywhere on the planet. It's an appalling piece of law, second only in terms of its opaqueness, if that's a word, to the current generation of Australian law. But its purpose was brilliant. And it wasn't actually it wasn't really the first law to look at this idea of confiscation. In Malaysia's law, which is far better drafted, it's a beautifully, well, the 2001 Act is beautifully drafted. It's been a bit messed up since, but the original version was very clear. And one of the things that the Malaysian law said, which has only recently come about in a number of other countries, is that it's not necessary to prove a specific conviction to be able to confiscate the proceeds of the conduct. Although a court in Malaysia has recently tried to go behind that. We're awaiting a decision on that. So the fact that the UK produced, from what we might call a leading country, an effective proceeds of crime legislation was actually very groundbreaking, and it dragged the US, which until then had primarily looked at the questions of whether or not the proceeds were an instrumentality of crime. So they're in rem actions where they would, my favorite case is the one about the red Corvette, for example, where if something was used in the commission of a crime, but they were approaching criminal assets from a perspective that in the UK we would have always said, well, he's a housebreaker, he's got a gem in his hand, so we'll confiscate it. Very different perspective, and the stuff that you were doing turned that on its head.
Yeah, and I think the important part about this is that there are different types of asset recovery. And most countries, all countries really, can deal with the instrumentalities. They can confiscate the thing that was used to commit the crime. They can confiscate the thing that was the object of the crime. So if you steal money and put it in a bag, then theoretically most countries can take the money back and they can take the bag as well. What countries don't seem to be able to do is get the proceeds of crime. So if you've been a thief forever and you've bought your house with it, then most countries simply cannot get the house. And there are actually 5 different types of asset recovery. Most countries have the instruments, they have the proceeds of a particular crime, but they have to show the connection between the crime and the object. And And that just doesn't work in the modern age against organised crime, or indeed anybody who's doing crime as an occupation. And the Proceeds of Crime Act is what changed that. And in particular, we've actually got a statutory definition of being a criminal, Section 75, which describes, if you asked someone on a bus, what's a criminal like, and they gave you a series of criteria, that is Section 75, a marvellous piece of legislation, that particular section. And that's a metric. We could use it as a metric. These are people who are criminals, who've not just committed a crime, but they've committed a list of crimes, or crimes in a particular way that are relevant to finance. They've made money from their crimes. And Section 75 describes that.
Well, you and I have, over the years, debated, and nobody's ever won, the term asset recovery. You like it, and I think it's misleading, but really just joshing about buzzwords, because you see asset recovery from the police perspective, which is, there's something we want, let's go and get it. I see it from the English lawyer's English perspective, which says, we're not recovering proceeds where it comes from drugs trafficking. We're not recovering money which is used for the commission of a future crime. They are being confiscated, but we do recover the proceeds of fraud, because we're looking to get those back for somebody. So the civil litigator in me says that's what asset recovery is all about. It's all about tracing stuff which has been stolen effectively, and looking to get it back for the person who has lost it. So this is why, when you from a law enforcement perspective talk about asset recovery, and I from a civil litigator's perspective talk about it, we're actually talking. What I'm talking about is included within yours, but a lot of what you talk about is not included within mine.
Sure. And no, I see the difference, and it is semantics, I think, to a large extent.
It's semantics unless you're looking to defend it, because I don't see it as an empty argument, because it is where the money goes to. When you're doing asset recovery, most of the time you're looking to get it for the state, and the state has never lost it. Whereas when I'm doing asset recovery, I'm looking to get it for an individual who has lost it.
Well, I'm doing both, because if we get a confiscation order, then we get a compensation order out of that. So the confiscation order comes first, and then you award compensation from that. And the reason to do that is because you have more powers to confiscate under the Proceeds of Crime Act. So you can use criminal powers to enforce it.
You do, but some of your colleagues in the Met used to hate me because I didn't wait for you. I would go and freeze assets before I made the report. So that
I really don't care, provided the point is to deprive criminals. So how we do it is academic in a way, but some forms of asset recovery, I'm sure I try to use that term, some forms of taking money off criminals using the Proceeds of Crime Act are really, really effective and not available in the rest of the world. And that's a really key difference.
I think that one of the important things that it's very easy to overlook is that I used to freeze assets that I could reach. And I would do that, and the police got upset about it, because then those assets did not feature in their recovery figures. So it kind of undermined the PR value of what they were doing. But if I could get those assets frozen for the benefit of my client, then I could get those assets back to my client perhaps years before a confiscation order was eventually made in a criminal trial. And so there was an imperative. I mean, acting for businesses as I did, there was an imperative to be able to get my hands on that money as fast as possible. And I could get a civil trial through much faster than the police would get a criminal trial through. So this was why I took the steps that I took. But if the money went overseas, then I was floundering, because I did not have the ability to pursue internationally in the way that you as a policeman could pursue internationally. And so once the money was offshore, I was more than happy for you to deal with it, even though it would take 3 or 4 years, partly because it would take me that same time, or maybe even longer, or maybe I'd fail.
Yeah.
But also, the police were free. My
Yeah.
client didn't have to pay me to start trying to chase money into a dozen different jurisdictions, most of which would have been deliberately obstructive. So I didn't always want to take it away from the police, but where I could get the money and hold it in the UK, then yes, I did. And I think that's a distinction that is often lost, is that these two things do work together.
Absolutely, yeah. I'm a great believer in public-private partnership. I don't care how it's done. The important point is to deprive the criminal, because that's a public good. That's the reason to do it. And if compensation results, then that's even better.
Absolutely. I think that what I see as one of the biggest problems here, though, is the law isn't clear enough and the process is too slow. It's too complicated. And at the end of the trial, convicted criminals get to negotiate how much they're going to pay, and therefore how much they and their families and their associates are going to get to keep.
Well, you're particularly focused there on fraud, and I do agree that fraud trials take far too long. And it seems to me, if fraud trials take too long, and they seem to all over the world, then we need to rethink how we try fraud. Because if you go and talk to an officer or a prosecutor outside a courtroom and say, can you just explain this case? Then in 2 or 3 sentences, in maybe a couple of minutes, they'll explain the core of the case. And inside the courtroom, it takes 6 months and costs millions. So we should be closing that gap in order to deliver justice, because justice delayed is justice denied, to the defendant, to victims, to society. And actually, we really should address the length of time that trials take. And the reason that we have these new financial gadgets is to get around that core failure in the justice system. That's why we have unexplained wealth orders. That's why we have deferred prosecution agreements. These are all because of failures to address justice in the courtroom. And that's something we should get to.
Why is it so easy for the defense to muddy the waters and to make these things take so long, so that ultimately the Serious Fraud Office says, oh, we've had enough of this, let's do a deal?
Well, I think the reason is because we haven't really, as a government or governments, we haven't really addressed the key issues. And the courts would say, well, this is how we deliver justice. We have to allow justice to give a voice to the defendant. It has to be seen to be fair. But I think we spend it's just ridiculous, the obfuscation that goes on in court, when actually common sense should allow us to get to the nub of the issue without, confusing the jury with a lot of confusing and unnecessary detail. And I think we should do that. Jonathan Fisher is currently doing a review of disclosure. I mean, he's particularly focused on digital evidence, but I think he should be looking at the length of time that fraud trials take.
How much of this is because judges don't control the courtroom and they don't nail down what's allowed to be put into court before the trial starts? I have in mind a parallel situation, and we've seen it. It's on Sky News today. A similar situation to the one I'm talking about. In 2022, we had a decision in a Bristol court. I think it was Bristol, where a group of 5 young men who tore down a statue and threw it into the harbour were found not guilty. Now, to me, that should have been an absolutely simple case. The judge should have nailed the whole thing down and said, I don't care about motive. That is not a question for the jury. I only care about intent. So the only questions for the decision, for the consideration of the jury, are these: did you do it, and did you intend to do it?
Well, the defence in that case was quite clever, because they focused on the lawful excuse, and they said that the statue belonged to the people of Bristol, and the defendant said, we are the people of Bristol. because that's what it actually said at the foot of the statute. And they said it's a lawful excuse. The statue actually became more valuable as a result of being thrown into the water and becoming an object of fame. So they said, well, we haven't created any damage. We've actually added value to this statue, which was true. So there was a good defence in those cases. So the lawful excuse was the issue in that particular case. Very interesting.
I came down wholeheartedly against that when I read it. I take a very simplistic view. I mean, the lawful excuse is kind of what you hear from graffiti artists who say, "But that white wall was ugly. It was for the benefit of the people that we painted it, or whatever."
I'm not forming a judgment on that particular case. I just admired the defence submissions. I thought they were excellent.
Yeah. So you don't think that it's necessarily as simple to say to a defendant, "Did you have this money? Did you intend to have this money?" And then for that to be the core of the case.
Well, I think that, to quote Jeffrey Robinson, who I do think has got this nailed, every fraud consists of a very simple, I tell you a lie, you give me money. They all boil down to that in one way or another. And actually, if you can get it down to a single sentence, then why are we spending months and millions in courtrooms? There must be a way that we can reduce that. And all of the gadgets, as I say, are creations because we're failing to address that core issue.
So this is really why financial crime cases are not as successful as we would hope, because we allow the defendants to run them.
Well, I think there are things that we can do. I think the non-conviction based confiscation is a really useful way to proceed. And people think about that in terms of the Assets Recovery Agency, which had a relatively short lifespan in London. But actually, there's another form of non-conviction based confiscation, which is cash seizure and forfeiture, which I think is very underrated in terms of its impact. And about a quarter of confiscations in the UK are cash, even though we live in a cashless society. So somehow there's a lot of folding money, which is still in circulation, which is making up a significant percentage of confiscations globally. And the UK is blessed to have a specific power which allows us to take the cash away immediately, which has an immediate impact on crime and criminality. It's very rewarding to do. And police officers all around the world, including your country and the countries around where you are regularly finding cash in premises and leaving it exactly where they found it, because they don't have a power to do anything else. And in fact, we were trained in the UK to leave the cash there where we found it. So the difference is not about a change in tactics. This is a change in the law, which allows us to seize cash. And that means a culture change. And if we are to change the way we approach financial crime, we need a culture change. And cash enabled us to do that. And the reason is this: once you've got a big bag of cash, management have to be involved, because it has to be banked, it has to be made secure, it has to be counted. You have to litigate it. So the prosecutor has to think of a way to litigate. Otherwise, they have to give it back, which is a terrible, terrible thing. So the prosecutor then looks at, oh, what do I do? Oh, there's this newfangled offence called money laundering. And it was the cash that drove a few dozen money laundering cases to be thousands of money laundering cases in the UK, all based around the cash, which gave our police officers and our prosecutors experience. Our courts became experienced, our judges became experienced. And once they were experienced in dealing with cash and the further investigations around that, then they could deal with the bigger cases. You know, that's why we're where we are in terms of those big cases, because we climbed the foothills before we tackled Himalaya.
Yeah, and that's something that a lot of countries have not sought to do, isn't it? They've just gone straight for the financial sector and said, it's your problem, we're deputizing you, go and spend an absolute fortune, disrupt your businesses, and if you don't, we're going to get you into trouble. Whereas,
and I have sympathy with both the financial sector, which is being imposed on, and prosecutors who are actually scared of taking the first step with laws that are untried, and nobody wants to take that first step, and therefore they pass it back to the financial sector. And I think the financial sector, the compliance industry, doesn't get justice from governments and their agencies. I mean, I really think that's a key issue, and part of the reason is that they're apprehensive about tackling financial crime. Part of it is a lack of resources. A lot of it is just a lack of experience. They don't know how to do it, and they don't want to be the first. So we should look at the UK and say, well, why were you so successful? Why did you go from a few tens of millions to billions of pounds being confiscated? How did that happen? How did that change happen?
I can tell you the answer to that, and you already know it. The answer is because it was police-led, not regulator-led.
Yes.
And now we are regulator-led, and it's all falling apart in the biggest possible way. The police are struggling to get the information they want because the financial sector is so scared of doing anything wrong. Because if the police find that the bank has done something wrong and tries to work with the bank, the regulator comes along and says, "Hey, give us £20 million."
Yeah, I'm not going to disagree, Nigel. I do think that's the issue. I'll go slightly further in that in the UK, it was police-led, but it was led by the ground floor. It was led by sergeants, actually. And they're the ones who actually were deployed by middle managers. So I think one of our mistakes in the police in the UK originally was we trained all the financial investigators with the new law. We very nearly missed out cash seizure altogether, actually. Literally, it stayed on the cutting room floor until I picked up the piece of paper. My guys were matching the two bits of paper from old law to new law. And I said, well, what's this cash seizure thing? And they said, well, it's a new thing. I said, well, who does it now? They said, well, Customs do it. I said, okay. So I phoned up my pal in Customs and discovered there was a seminar taking place, I think the next day or the day after. So I said to my trainer, who was on his way home, I said, come in here for a minute. What are you doing tomorrow? He said, well, I'm just here, boss. He said, well, okay, I need you to go to Customs, find out what they know, bring it back. So we adopted the Customs procedure that had already been in place for a decade, tried and tested in the courts, and we used that to seize cash that the police were finding. And from the 1st of January, the police would be finding cash in houses, in cars, on people in the course of ordinary operations. And previously, we left it behind. Now we seized it. So it was very much driven by the operational ground floor as an extremely effective way to tackle street crime, ordinary crime. And from that, we built up to the expertise to deal with more serious cases. And the prosecutors came with us.
I think it's very useful to remind people that in the UK, we do not have cash transaction reporting. No. And so, whereas in, for example, the USA or a number of other countries, the mere fact somebody's got, say, $10,000 lying around would have to be reported to a bank if they try to transact with it. But in the UK, that doesn't happen as a legal measure. It happens as a risk measure very often. Yeah. But which is how I think it should be. I don't think it should be a legislative requirement for cash transaction reporting, but I think that it should be a feature of suspicious transaction reporting that the bank or whichever business it is identifies this and says, this for that customer, this amount of money is unusual, therefore we should report it. Did you have any kind of trigger figure when you found cash in a house, or did you just think, well, that's 500 quid, that's bound to come from drugs, let's nick it?
The original threshold was £10,000. Had to appear to be £10,000 or more. Very swiftly, within a year, it was 5,000. I think within a year and a half, it was 1,000. So the threshold was defined by law, but rapidly came down. I do think thresholds have a utility, but it's not the one you think it is. They're useful as an intelligence measure, because if you can capture transactions which are just below any threshold, then they're the dodgy ones.
Yeah.
So,
I mean, £1,000 is not very much money to have lying around the house.
no, it isn't really. I mean, it would be unusual in the UK, to be honest. I mean, I would
Really?
rarely go out with it. I mean, £50 notes are hardly used, to be honest. And that's our biggest denomination.
Yeah. I find that quite surprising. I mean, I've not lived in the UK for 20 years. But to me, well, I went to the UK 18 months ago and I had more than £1,000 in cash because I wanted pounds. So what I actually did was I collected all of the different pots of currency that I'd collected over the years from traveling and took them into Marks and Spencer's and said, give me pounds. And it was well over £2,500. So I would have been subject to confiscation for that.
Not at all, because you would be able to explain yourself, wouldn't you?
Well, this is true. Well, although it's quite hard. I've got 35 different currencies, and it comes to £2,500.
Yeah, and then you whip out your passport and say, go and look on LinkedIn, and you'll see that that goes with my lifestyle. I mean, I do. The police can't just take money because they feel like it. The issue is that the police are going into houses and searching cars and people because they've already got reasonable grounds for something else. They're not looking for cash. They're looking for stolen goods, or they're looking for evidence of some kind of crime. They find the cash, and it's incidental to the reasonable grounds that they already have. The point is that the police in the UK can seize it and then forfeit it, and in the rest of the world, they can't. And as a result, we're leaving hundreds of millions of pounds in cash all over the world.
Zimbabwe does. Zimbabwe passed a law when it was printing its IOUs on photocopy paper. It passed a law that if you had more than a very small amount of money in your house, then that could be confiscated without warning. That was in bad old days. I'm not sure that things have got much better. But the USA, there was a rumor, I'd put it no higher than that Amtrak used to run its search dogs on its share of confiscated money, because it used to find bags of money on trains all the time. I'm not sure how true that is, but it's an interesting perspective that just because there was money, there didn't need to be suspicion. If the dogs found it, they would have it. And I've always been amused by, possibly, yes. I've always been amused by the fact that I get sniffed at by a dog every time I go to Jersey. The UK's Home Office, Treasury, regulators, and the world and his granny keep coming up with what they say are new strategies to combat what, for some reason, they term economic crime. I've become so jaundiced over the years that I've given up reading them. I got fed up with lots of words and no properly focused improvements. They're just fiddling around the edges and spending time that law enforcement could put to better use in just making what we had 20 years ago work. But you read them all. Can we cobble together a working plan from all these documents? And if so, what would your top 3 changes or reinforcements be?
I mean, I do think we need to build on success. And at a global level, I think we could build on success. And what the Financial Action Task Force has done over 30 years, and I'm a fan of the FATF. I'm a critical fan, if you like.
You and I will get to blows over that.
But when they started back in 1990, money laundering wasn't a crime. There was no mechanism nationally to coordinate agencies. There was nowhere to put the information that the financial sector had. So over 30 years, the FATF created the crime, in every country. They created financial intelligence units in every country. They created a national mechanism which coordinates, theoretically, agencies in the private sector, which are more or less good. It varies from country to country. And then in 2012, they moved from compliance to operational effectiveness with the new methodology. Now I think it's disappointing that they've stuck with compliance, because if it were me, I'd emphasize the operational effectiveness. So that would be a change for the FATF.
I think you and I agree with that, because one of the things I have said, well, two things I've said. The first is the FATF had finished its job by 1999. It should have been wound up. It's done nothing of any value since then, in my view. But it should be subsumed into Egmont. And I've seen that it has recently started to work with Egmont. But I think Egmont has got a much more valid purpose and much more relevance than the FATF has had since 1999.
Yeah, okay. I think both have value, and I don't think we should junk the FATF. I'm not averse to it developing into something else, but I think it is an institution which has some credibility. It's well recognised. Everybody understands it. I just think it could do better. I think it could focus on delivering best practice as a result of its evaluations. I think rather than a snapshot of a particular country, it should be looking at each country and looking at the financial flows to and from that country as part of the evaluation process. And at the moment, we get a snapshot which doesn't look at the illicit financial flows. And it wouldn't be that difficult to do that. So there's room for the FATF to develop.
Actually, we do agree. If it gave up with its politics and just focused on dealing with money laundering, it would actually possibly be more successful.
It'd be nice to get rid of politics, wouldn't it?
Definitely.
But there we are. The things I would like to change in terms of economic crime. Firstly, the first rule of economic crime is don't call it economic crime. Because as soon as you add that word, it's dangerously close to academic. Who's the victim? What, the economy? I mean, who cares about that, really? I mean, we all generally care, but we don't specifically care in terms of economic crime. Crime is about people. Crime is about harm. As soon as you add economic, then you lose the interest of law enforcement, which is relevant, because if we're going to win this war, then we've got to have boots on the ground. It's the police who've got the numbers and the experience. And if you call it economic crime, then it gets pigeonholed into a smaller and smaller pigeonhole. In some countries,
doesn't understand it either, because it doesn't relate to it. I use the term economic crime in a very limited form, where it's offences against the state. So I don't even include tax evasion in it particularly, but I would include, for example, plunder and grand corruption where it involves the state, but not corruption where it involves a company, for example.
Yeah, I mean, I'm not going to disagree with that. My difficulty with economic crime is that law enforcement just aren't interested in it.
Yeah.
And when I joined the fraud squad, which is where we started this podcast, I'd already joined the Titanic, because the police, the Met Police in particular, had decided to move away from fraud because it was victimless, because the trials took too long, because the City of London could probably do it, or companies could defend themselves. So when we said fraud, we just lost resources. So we thought, well, what do we do? Well, let's change the name. So we changed the name to Economic Crime Unit. Well, that didn't work either. And we would have disappeared altogether if the Proceeds of Crime Act hadn't come along and saved us all. So economic crime is just the kiss of death for law enforcement resources. And we need to have law enforcement and the justice systems on side. So we've got to call it crime. We've got to talk about harm. And I think we've got to talk about financial investigation as not a silver bullet, but close to. And if it was one change I'd make, then I'd move away from fraud squads and economic crime squads and burglary squads and murder squads. And I'd have financial investigation squads who have access to SARS and who follow the money back to the crime. And people talk about follow the money as a mantra, and I agree with them. But we should be following the money back to the crime, not following the money from the crime back to the perpetrator, because that flow is much easier. If you start with dodgy money, then you know it's dodgy because you've got the suspicion. You can start a money laundering investigation, which triggers all access to Egmont, triggers access to new powers that you can use in domestic legislation. So you follow the dodgy money, and that leads you to the crime, whatever it is. And that might be fraud, it might be burglary, it might be robbery, it might be drugs, whatever.
I understand that coming from a civil litigation background.
Okay.
But coming from the very small amount of criminal defense that I did, I have a problem with it, because I have a problem with it from your point of view, because I would look at that and say, everything you did was tainted by prejudice because you decided that money was dirty, and so you decided to prove it. But if you go the other way, you would say, there's the crime, there's the money, there's the person who's benefited from it, and I would not be able to raise a similar argument.
Well, it would become relevant quite quickly, because the reality is that the way we use SARs in practice is very rarely do we take a SAR and then build a case on the back of that SAR. What we do is we take the SAR as half a needle in this needle in the haystack analogy. The SAR is half a needle, the criminal intelligence is the other half of the needle. You put the two together and you've got your needle. So we start with the SAR in order to start our investigation based on suspicion, which is a valid. By the time it's been, through the cashier to the manager to the MLRO to the FIU and out to law enforcement, I mean, each of those take a percentage away. By the time it gets to law enforcement, it really is suspicious. Yeah, because everybody says it is. And in the course of the investigation, you typically find the predicate crime. So before you actually get anywhere near a court, you're already investigating the crime, and you've got the money already. So your argument falls away in practical terms,
which is good.
Which is good. We agree, as so often.
Exactly. This is, as I said at the top, people who listen to us or read what we write will often think that we don't agree, but in fact, we end up in the same place, but we start in different places, and that's why it's so useful for us to have these chats. Okay, we're almost out of time, but in closing, you've written an extremely well-regarded book with Nicholas Gilmore, The War on Dirty Money, and I have a somewhat esoteric question. Is it a war in the sense that there's a war on drugs, that is a lot of noise but no sign of victory? Or do you think that we can ever make a serious dent in particular money laundering? And if so, given that we've got 3 decades of failure, how can we turn that around?
Well, I'm an optimist, and I wrote the book with Nick because I think it was a good title. We didn't call it The War on Economic Crime for a reason. And we've actually made a lot of progress. We've done the difficult bit. We've created the army of compliance people, and lots of people are paying attention to crime and the money that comes from crime. So we've got an army of people. We've got a series of tried and tested weapons, legal weapons that we can use. And we've got coordinating abilities through the FATF and the idea of the FIUs and suspicious activity reports. We've got all the means to go to war. What we're not doing is making an advance. So we actually need to give law enforcement a chance, give them the SARs, give them the resources to take the war to the enemy and actually arrest people and prosecute them. And we're not taking that step. And if we did, I think the world would be a better place. I do think this is a global thing, that there's lots of crimes which are not being addressed. Crimes against the environment, crimes against human slavery. These kind of issues lend themselves to being investigated financially, because the penalties very often for breaches of regulations or building regulations or something are very derisory, whereas confiscation actually could be a huge amount of money. And building regulation, I pick it because it seems a harmless thing until the building collapses and people die. And so we have an opportunity with financial investigation and confiscation to tackle the crimes that other mechanisms don't reach.
But we have to
Mhm.
convert some of that conduct into actual criminal conduct, not regulatory criminal conduct,
Yeah.
or not regulatory conduct. I mean, it's when you have a breach of building regulations for which the only available penalty is a fine. That's not really good enough. That has to come into the mainstream criminal law, where jail time can be given, and as well. So, and I know that's complicated. I know it's difficult to do, and all the reasons that it's not done. But if you're going to follow the plan that you have, then these things have to be proper crimes, not regulatory offences.
Sure, I'm starting from a British perspective, and planning law is a crime. It's in criminal conduct, and local councils regularly get confiscation orders for breaches of planning regulations. And I was reading about cases this week. It happens on a regular basis. So it depends on the legal code of each country.
That's done outside the police system. Do we think that all of this should ultimately fall within the police, however we define that, rather than there being fragmented enforcement across a multitude of different regulators?
Yeah, it's a really good point. I've talked about the formation of financial investigation squads. That's essentially what I ran in terms of the London region asset recovery team. And that was a multi-agency team, a permanent team, not made up for a particular crime, composed of customs investigators, City of London, serious organised crime agency, trading standards investigators. So multi-agency team. And I see that as a good model going forward, because it brings different professions together, and they enrich the investigation. And we have in the UK something called the Accredited Financial Investigator. So all financial investigators on any agency, all trained to the same standard, all mentored after the course, one big profession. And we almost got to the stage where people were AFIs first, police officers second, financial investigators first, customs officers second. And we got quite close to forming a full profession. And I think if we'd given them the same terms and conditions, then we would have built a genuine profession and allowed people to move from agency to agency, and that could go international. I think there's room for that to go into the private sector as well. We'd have to build some caveats and some security around the exchange of information, but I think you could take the concept and go into the private sector and have this two-way door between the private sector and public sector, because a lot of people want to work in the public sector because it's really, really interesting. That's where the real crime is.
So why did it go wrong?
Where did it go wrong? Well, I think it went wrong because of reforms to the police over the last 10 years in the UK, and we kind of lost an impetus, and we kind of lost, and we didn't actually recognise the success we'd had in the UK is one reason. But I think we got distracted by other things in policing, by very big reforms to police in the UK, changes to terms and conditions, sale of police stations. I think that took our eye off the ball because of the cuts, distracting management to the challenge of austerity.
And a focus away from what we might call proper crime towards a whole raft of social offences, which really don't actually, they affect the individuals concerned. They're antisocial behaviour effectively, but we now see those being taken up by local police forces, and at the same time they're just saying, "Oh, that's fraud. It's too hard. We're not going to do that."
I'd put a positive interpretation on those non-crime pursuits that police are doing. The reason we can do that is because crime dropped off. Crime had risen year on year for decades up until the 1990s. From 1995, roughly, that tsunami of crime kind of fell away. In the beginning years of the 2000s, the Process to Crime Act came along. Crime kept falling. And the reason that we're dealing with with other things, is because we're not dealing with robbery and burglary anymore, because that's not a thing that happens in the same way that it used to. So there's a massive fall off in crime.
We had a big upsurge in knife crime and the serious end of antisocial behaviour.
Sure.
And those took an awful lot of resources. So how can we make governments realise that that it's important to get back to dealing with financial crime as a priority, not just in the UK but elsewhere too?
Well, I think if you tell them economic crime is important, everyone in government and agencies will say, well, not compared to murder or other harmful crimes, not compared to human slavery. When you're just never going to win that argument to say it's more important. So the way to do it is to say something a bit different. Say, well, actually, financial investigation is something that brings money to the state. It improves the morale of law enforcement. It really makes criminals very cross and unhappy, and reduces crime. And it brings
to make criminals cross and unhappy. Let's finish with that. Tristan, thank you very much. Excellent to have a chat. I'm sure we'll talk again at some time in the future. Tristan Hicks, thank you very much.
All right, cheers. Thanks a lot.